Before we dive into this video, Madlanga Commission and General Dr. Van Rooyen's testimony, let's step back and really ask ourselves what makes a law good and why should ordinary citizens care about law? I've been really doing some research about law, and of course, I'm not a lawyer, but there are principles of law that are very simple but powerful. And one of those principles is that the rule of law. So no one is above the law, no presidents, no ministers. There's also these separations of powers. The ministers make policy, but commissioners, the national police commissioners, they run operations of police. Now, also, there's this thing about clarity and legality. Laws must be clear and predictable, not twisted by semantics. And also the fairness and accountability. Officials must be held responsible when they cross the line. And we're trying to, South Africa at the moment is on the, I would say, crossroad around this Senzo Mchunu saga. Not just Senzo Mchunu, all political parties looks like they're all involved in this. And above all, there is also a good law that protects rights. Law must protect your rights. It doesn't shield the powerful, but it serves the people. So when us as a citizens understand this principle, uh, you know, we can see through the political theater. And yesterday I was looking through it at Madlanga Commission. I was like, oh my God, this is political theater now. And that's why Dr. Van Rooyen's stand yesterday matters. That video matters. If you're South African, you need to go back and have a look at that video because it's so important that you listen careful to what she said yesterday. And because she argued that the Minister of Police, Senzo Mchunu's directive for seizing the political killing task team in South Africa, the operation of police, was just wrong. Wasn't just wrong, but was also unlawful because it actually went into the and set this operational authority that it's only reserved for commissioners, not politicians. So, the Constitution of South Africa, Section 207, draws a clear line. The minister sets policy. The National Commissioner of Police has control and management of police. No minister can lawfully cross into day to day operations. All right, let's listen to Dr. Van Rooyen really make this statement very clear to the commissioners.
The National Commissioner holds the ultimate authority to control and manage the entire police service in accordance with the National Policing Policy and directives from the Minister of Police. And this is provided for in Section 207 of the Constitution. The National Commissioner ensures the police fulfills its constitutional mandate, which includes preventing, combating and investigating crime, maintaining public order, protecting people and their property, and upholding and enforcing the law.
General, in 34.1, when you say holds the ultimate authority to control and manage the entire police service, would that include the Deputy National Commissioners?
Yes, indeed, sir.
And when you deal with this evidence, can you also deal with their role as well? Because I see that after this section, you go to the provincial commissioners, but you don't say a lot about the deputies.
Okay.
And that is important in the context of the allegations made against General Sibia.
Okay.
And what authority he had to do certain things.
Okay.
Yeah.
Commissioner, do you want me to deal with it now, or can I go through the key responsibilities?
You can go through them and then deal with it afterwards.
Okay.
You don't know how many times they interrupted her. I was counting. That was shocking how they interrupted this, actually. I was annoyed. So We're going to play another clip here by the very same commissioners asking questions, and I actually noticed some biases in their questioning. And there's another hypothetical question around torture. I mean, that one nearly fell off my chair when I had this one. So instead of them actually taxing Senzo Mchunu's directive directly, this directive that he issued that was unlawful, the commissioner, the commission chair, the Madlanga Commission chair, raised, the torture. Yes, torture is hypothetical and loaded, really loaded and extreme. Really, this hypothetical thing was really designed to justify this urgent ministerial intervention, not to say that he did it because he wanted to protect the illegal syndicates, the criminals, the mafia, the drug cartel. But they say, oh, maybe there was his directive. He can issue an agent directive, maybe in public interest, but there's no public interest here. Public interest is for police to continue with their work.
As contemplated by Section 207, could he competently direct the when aspect?
No, he
as
cannot.
opposed to the how. In other words, when.
No, you cannot, because once again it will have operational implications. The whole issue of the continuation of investigations. Let me give a very simple example. That court case that was supposed to be heard on the first working day in January, what should have been done with that case? Should the investigator have simply withdrawn and say, I'm not involved in this investigation anymore? If there was a bail application, should the investigator say, I'm no longer authorized to, as a member of the political task team, to attend to this matter so that there's no one in court to oppose or to assist the prosecutor in opposing bail? So the practical implications of that, in other words, the immediately and also the how, is definitely problematic, and it shouldn't be left to the executive in view of the implications that it will have on policing.
But surely that would depend on the nature of that which has to be done. I know something like acts of torture, for example, are addressed as a matter of law elsewhere. But if despite the existence of such law, the minister is of the view that torture is committed by the police, what would be wrong if the minister were to say, I am issuing this direction and I am saying this must stop immediately? I'm just giving that as one example to make the point that surely it would depend on what the direction is about. And you cannot in a blanket manner say that it can never be immediate when it's issuing from the minister.
Chair, I agree, but in your example, torture is already an offence. So the minister cannot...
That's exactly why I preface what I say by saying, with torture, there's already law about it.
Yes.
I would imagine that, put it this way, one cannot discount the possibility that there may be any number of other examples that may require immediate action, which may not necessarily mean that that becomes unlawful purely because the minister says this must happen immediately. That's all I'm saying.
Yes, I agree. But even in those circumstances where an immediate action is required, the decision must be rational. And rational requires it must have a lawful basis, and also it cannot be arbitrary. And I believe
I'm very sorry to interrupt you. That's something else altogether. I'm just making the simple point that surely it should depend on the nature of the direction being given. Yes, of course, whether or not it's lawful, it would have to comply with the law, including the Constitution. You are touching on irrationality
that's something that would be unconstitutional in terms of the Constitution, but that doesn't address the debate you and I are having now, which is that surely it may depend on the nature of the direction, and depending on that nature, in certain instances, the minister can be able rationally and lawfully to say this must be done immediately, this must stop immediately. Surely you cannot discount those possibilities. Otherwise, I'm not taking away from your point, but I'm just saying that you should not make the point so categorically as to discount those possibilities.
Chair, I agree. Circumstances may dictate that immediate action is required.
Yes.
Thank you. Thank you, General.
Thank you.
Mr. Mtawi, just last one for me, just to make sure I understand. General, if the minister had said, and let's come specifically to the PKTT instruction, if the minister had said to the National Commissioner, I want the political killings, the political killings that are the focus of the PKTT to now no longer be a priority in the list of priorities, no longer be your priority. Here's a new priority that I want you to focus on. If that's what he had said about the PKTT, would that offend the separation of policy and operation? Would you complain if the minister had said that?
Chair, in taking the cue from Commissioner, in taking the cue from the chair, I believe there may be circumstances where that is required. However, I also want to be careful to say that will also be always the case. But I fully understand there may be circumstances. Let's say there's a huge explosion tonight and a city is completely obliterated. Then the minister may say, don't attend to this, immediately go there and attend to that matter in view of the urgency of the matter, to simplify your example. So that may in circumstances be required, but I am hesitant also to say that will always be the case. I think we need to consider the circumstances of a specific incident.
The South African Constitution, Section 207, draws a very clear line that the minister sets policy. The National Commissioner of Police has control and management of the police. No minister can lawfully cross into day-to-day operation.
Distinction exists between the political responsibility of a minister and the operational control of a national commissioner. The minister focuses on policy, governance, and political accountability, whereas the national commissioner controls and manages the day-to-day operations of a police service in accordance with the minister's policy directives.
So then the Commission argues that the directive is not unlawful merely because it's immediate. You know, when you hear him speak about this policy directive versus adjectives, playing with adjectives, urgent, immediate, instead of really focusing on whether the minister crossed the operational line. Again, this whole narrative that I have formed around, there's an element of bias here. They're not really focusing on the issue here. They're trying to provide some alternative that are really far from removed from the subject matter here. That's my opinion.
This structure.
Sorry, General. I may be mistaken. I think you are using the term policy directives for the first time. Perhaps Advocate Sigels Ngube could help us with the word search control find and see if it does appear before now. But let me continue so long. By directives, are you referring to the same thing as directions, which is the word referred to in section 2072, or is your idea of directives something different?
Chair, my idea is, as I explained the directives earlier in my testimony.
I'm asking a direct question. Is that the same thing as a section 2072 direction, or is it something different?
That is the same thing in my understanding, yes.
All right. Now, you seem to collapse what appear to be two concepts, collapse into one, what appear to be two concepts in section 2072. Section 2072 refers to policy and directions. The very fact that the Constitution puts them like that suggests that they are separate concepts. I do not know, perhaps through an interpretative exercise, one could say there isn't really a difference. I don't know. But the Constitution says policy and directions, and you've suddenly collapsed them into one. Policy, directions. In fact, you simply use policy now as an adjective, qualifying the noun directions, so that what for you appears to be the most important concept is directions.
Yeah.
So policy is merely adjectival, whereas the two appear to be two separate concepts. Do you want to please comment on that?
Chair, I concede. You are correct. The policies, as I explained, are more long-term written documents. It gives the goal, the government's goal, to achieve certain objectives, albeit in the national policing policy, or the example that I utilized to remove barriers in the reporting of certain offences, and it aims the implementation by the police of long-term goals. These are not things that can be achieved overnight, but it is constant goals that should be entrenched in the police, in its operations, working towards that goal and ultimately achieving it. That would be my understanding of policy. Whereas directions are more short-term, immediate action. As I indicated, it can be written or verbal. What are you doing about gangsterism? I need a report, or I need you to do something about this. And in that regard, my statement may unnecessarily have caused confusion, for which I apologize.
No problem at all, General. I've actually also been exercising my mind over what these mean. I know General Masemula.
The commissioner, they then returned to Section 207. But this time, to argue it actually supports the minister issuing directives, trying to argue that, to try to spin it, that the minister, it was okay for minister to issue these directives. Again, they're normalizing what Dr. Van Rooyen had just warned it was unconstitutional. This reframing of the constitution, and we've had this lots of problem with these judges in South Africa that are reframing words that are not there, are interpreting things that aren't there, that are not designed for that. Take, for example, everyone has the right to access to healthcare. I mean, that doesn't mean 6 billion plus people of the world should have the right to access healthcare for free in South Africa. Really? How dumb that it would be. All right. So these people, it's another problem I've had with them. They just not relevant. And I like the way she answered it, Dr. Van Rooyen. It's not relevant. It's not specific for this case. You gotta address law based on the context.
Now, do the Deputy National Commissioners account to or report to the Minister?
No, the Deputy National Commissioners report to the National Commissioner, and the National Commissioner reports, as the head of department, reports to the Minister.
Can the Deputy National Commissioners say, once a Minister has issued a directive, we are obliged to A, comply with it, B, implement it, notwithstanding what the National Commissioner says?
No, the Deputy National Commissioner does not have that power. And I am reminding you, Commissioner, that Section 199(6) of the Constitution says no member of a security services may comply with a manifestly illegal order. So the fact that it came from the Minister and it didn't fall within the purview of a Minister to give that order is already problematic. The correct approach would have been to report it to the National Commissioner and to say, I've received this order from the Minister and I'm reporting it to you to give direction on how to deal with the matter.
Now the focus has shifted completely. Of course, that's the Commissioner Khumalo asking the question. The question isn't whether directive was lawful, but whether the Deputy National Commissioner were obliged to comply and implement it. In other words, obedience, not legality.
A direction does not require to be in writing and may also include verbal instructions. It appears to be focused more on immediate or short-term action.
Just on that, General, was the disbandment instruction a direction as envisaged in Section 2072 of the Constitution? If not, why? I am aware that from paragraph 93 onwards, you do deal with the question whether the disbandment instruction was a policy or an operational matter. You do not deal, however, with the question of a direction. That is from 93 onwards. Hence my question.
Okay.
So was the instruction a direction or not? And why not?
Chair, clearly it was an instruction by the Minister. It also contained the word, I believe repeatedly, direct. The question is, was it a lawful instruction or direction in the sense, did the Minister have the power to direct or command the closure of a task team that was investigating crimes? And in my view, he did not have that authority because it relates to the operations, investigating cases and the operations of the police. In other words, the execution of the police's mandate in terms of Section 205(3). If we say the National Commissioner is responsible to manage and control the police service, that must be linked to manage and control the police service in the execution of its constitutional mandate. And the decision of a minister to close a political task team that was responsible for the investigation of crime, in my view, fell outside the mandate or authority of the minister.
So in short, what may be purporting to be a Section 2072 direction cannot be such a direction if it has strayed onto operational matters.
I agree with that submission or with that explanation, Chair.
Well, if I can just come in, it's not even a question of agreeing. I think the Chair is simply paraphrasing your statement and the proposition that you put.
Okay. I
so
confirm.
Yes. I think lest the Chair be misunderstood to say he put a particular suggestion. Thank you, Chair.
Sorry, Mr. Mtaka.
Yes.
General, two questions from me. One about directions. What would constitute a direction that does not offend, a direction from the minister that does not offend the constitutional structure?
Commissioner, in my view, especially if you consider public engagement, such as in MzansiOz, will be a place where the minister engages with the community. And if a minister, for example, during such an engagement with the community finds out that there's unhappiness, for example, in the Western Cape with gangsterism, and the minister tells the National Commissioner, you have to do something about gangsterism, that would be a direction. In my view, it will be a positive direction coming from the evaluation of complaints or engagements that the minister had, and this can be with the community or it can be with the politicians in the province. And that direction is based on what he was told by members of a community or members of the executive in the province, identifying a specific area of concern or where there's a problem, and simply telling the National Commissioner, you must do something about this, or attend to this, look into this. As I said, gangsterism, I believe, will be an example that all of us can identify with.
Okay, so not the how?
Not the how, no. Okay. And I would also be careful to say that the minister can close things. In other words, that can have an impact on policing. So if he makes a positive suggestion or a positive guidance to say, look, or what can you do about this? But to close something may have a ripple effect that is not something that is anticipated by a politician when that decision is taken, simply because he's not, he cannot be expected to be aware of all the intricacies of policing and how one decision can impact on a number of other aspects of policing.
And the second part, in your paragraph 26, that opening sentence where you say the need for clarity on the role of minister has repeatedly, with emphasis on repeatedly, been raised as a concern. This, I don't know if this is the intention that you sought to convey, but it suggests this is not a once-off, the case that we're dealing with now, or the facts that we're dealing with now. It's not a once-off thing. There's been concerns. If you like, systemic concerns about the role of the minister. Is that what you're seeking to convey there? And if you do, if that's what you're seeking to convey, what are the specifics?
Commissioner, to be honest with you, I think it was more within the context of the last couple of months that we've been consistently working and attending to the issue of the closing of the task team and the implications thereof. So there wasn't any strange intention to include the word. I think it's just something that is constantly part of our daily operations. And I believe the implications of that letter and the fact that we are sitting here today indicates the need or amplifies the need for clarity, not only for the benefit of the organization, but also for the benefit of the executive, to ensure that there's a clear line to stay away from in respect of both the National Commissioner and the Minister, but also for the organization as a whole.
Your answer suggests that until recently, the recent incidents with past ministers, there's not been the kind of concern about the roles of the minister.
Well, the role of a minister has previously been highlighted not only in the police, but in the Africa report on the July 2021 unrest, and the fact that the report or the commission held that there was an overstep of boundaries in the roles of the ministers during the policing of or steps taken to address the unrest. So it's not something that is completely new, and it's also not something that's only been identified in the police, it has been identified in other commissions as well.
This pattern, distraction, reframing, and compliance pressure suggest, at least to me, this commission is more interested in protecting the minister than testing his actions. And that's the danger here. It looks like we're watching another Zondo Commission 2.0. High profile inquiry, lots of testimony, but no accountability for those at the top. Cyril, all criminals are the same. Allegedly, of course. He chose them really well. He chose them because he knew they were going to be protecting this stuff. They're going to try and spin this thing. Even though the spin, it's not really reasonable. The hypothetical torture stuff, oh man, come on. Please come on, people. Yeah? Yeah, you see? Talk without teeth. This is what's going on here, folks. Yep. Tell you what, if the Madlanga Commission continues down this path, it will end just like Zondo, revealing truths but shielding the power. The question South Africans must ask: will this commission give us justice or just another performance? Will these politicians and all of these people who are implicated actually end up in jail? Justice or just another commission or just another talk shop that Ramaphosa can say, yeah, well done on me, I've done something, spent millions of rands on a talk shop. Comment below. See you guys. If you're new here and enjoy the things I talk about here, please consider subscribing. Until next time, see ya.